of Rotarians. The organization is built on guiding principles and a commitment to service, and I point to the four-way test as just one example of that, and I quote, it's a non-partisan and non-sectarian ethical guide for Rotarians to use for their personal and professional relationships. I'm going to speak to you today from a global perspective and from the perspective of what is happening in Ukraine, because that's what I have studied and that's the experience that I have. But I hope that these reflections are valuable to you and that you see how the principles and frameworks apply to the work you do in your local communities and the solidarity you uphold with your work globally. So, as mentioned, I'm a lawyer and humanitarian. I was called to the bar of England and Wales and will be called in Canada in June this year. I've worked for humanitarian organizations, for international institutions, and for government. And I'm also half Ukrainian and half Irish, and this informs my worldview. Please note that this presentation and any views expressed are from my personal perspective and don't represent the views or positions of my employer. And I just also want to note that the examples that I give today are illustrative and are not meant to suggest a specific opinion or to comment on the legality or the merits of the example. So now, I know some of you may be familiar with my story, and so I will be beating you over the head with this. Okay. I was 15 years old when I spoke for the first time at a Rotary Club. I stood up as a prospective Rotary Youth Exchange student at the Rotary Club of Edmonton, and I spoke to the club about what multiculturalism means in Canada, what it means to be a peacekeeper on a personal level, and what it would look like, or what I thought it would look like, when I went on my youth exchange to the Netherlands several months after that. And when I think back on that speech, just under 15 years ago, thinking about what it means to be Canadian, to be part of a multicultural country and world, it seems especially relevant today in light of the geopolitical context and the world we live in. I have a lot of gratitude for the principles and practice that Rotary has provided me in its commitment to truth, to fairness, and to think about how I could be of service to my community. I left for the Netherlands in my red blazer full of enthusiasm, adventure, and a desire to learn. I learned to bike against the wind both ways to and from school, but it also provided me with the experiences that have shaped what kind of lawyer and humanitarian I am. I know many of you have supported Rotary Youth Exchange by either hosting a student in your home or club, by providing funding and taking time to support youth programs more generally. I really want to underline just how life-changing it is. And I know you'll hear more tomorrow on the Youth Exchange program. But this has been incredibly meaningful and life-changing for me, and it was the start of my Rotary story and of my work now. In some sense, I am the exception in that my Rotary Youth Exchange launched me into an international career and has allowed me to work on issues of peace, justice, and accountability. But I think what is truly exceptional about this program is how it identifies and supports community leaders, those who have the drive and potential to be leaders and of service to their communities, and provides an opportunity to understand something different, to expand their worldview, and to bring that back to our own communities. I look at the cohort of my youth exchange year and those who I've been in touch with as a Rotex student, and it's these experiences that we had provided us all with independence, critical thinking, empathy, cross-cultural understanding, and principles that really help us give back. For me, one of the most formative parts of my youth exchange was the time that I spent at the Peace Palace in The Hague. The Peace Palace is the home to the International Court of Justice and the Permanent Court of Arbitration since 1899. Those are the primary judicial bodies set up to settle disputes between states, and in the case of the International Court of Justice, to also provide advisory opinions on legal matters. The Peace Palace is also home to the library, which is focused on international law. I was very lucky in that my host dad commuted from North Holland to The Hague a couple times a week, which for Canadians is nothing, but for the Dutch was crazy. But I would get rides and take the train to The Hague to go to the library and read about public international law, and specifically about the laws that apply in war. I read about the humanitarian principles, the role of different actors, including impartial relief organizations, and was left wanting to understand the legal, ethical, and operational realities of putting that into practice. I was struck by the idea that even in war, there are limits. I returned to Canada with just enough reverse culture shock and inspiration to continue to look for the next adventure. And so I moved to Ottawa to study transnational law and human rights for my undergraduate degree, working for the Canadian Red Cross in communications, international law, and government relations throughout that time. And I was also part of the humanitarian response to the wildfires in Alberta in 2016 and in British Columbia in 2017. In 2018, I moved to England to pursue my law degree at the University of Cambridge, still focused on issues of international law, and in 2021, I moved to Washington, D.C. to start my Master's of Law in National Security Law as a global grant scholar. Without a doubt, I would not be where I am today without the support of Rotarians. And specifically, I want to highlight just how much support I received for my global grant. It was not just from one club, but the district as a whole. And please do let me know if you're here today. But my global grant was funded by the Rotary Clubs of Edmonton, Edmonton Foundation, Edmonton West, Edmonton South, Edmonton Riverview, Edmonton White Avenue, West Block, and Wainwright. Even that is just so moving to me. But I was also supported by individual Rotarians, Cliff Draver and Harry Gate of Camrose Daybreak, Ted Gillespie of Camrose, Tamara Larson and Stan Bissell from the Edmonton White Avenue Club, and Ingrid Nietzsche from Edmonton West. And the absolute biggest shout out to Ingrid and Brian, who were my biggest cheerleaders and advocates for that year and always. So after my L.L.M at Georgetown, I went to Luxembourg to work for a judge at the Court of Justice of the European Union. And as that contract was ending, I found an opportunity to work as a policy, ethics, and legal advisor for an NGO in Ukraine. And suddenly, the principles and rules that I read about in my youth exchange became very real. I have seen how those rules have meant that my friends and colleagues are protected, and I have also experienced what happens when those rules are not respected. Now, I talked about being a peacekeeper on a personal level all those years back about to leave on my youth exchange. But the reality is that it is the responsibility of states to maintain international peace and security. Unfortunately, we're seeing an escalation of armed conflicts, of threats to state sovereignty, and the preparation for the possibility of larger scale conflicts. The suffering in war and the humanitarian needs that result are not new. I want to take you back to 1859 to the Battle of Solferino as a starting point for the legal and ethical framework in which humanitarians respond today. So I note that much is written on the various principles and developments of the conduct of war across cultures and throughout history, but when we talk about modern international law, I'll start here. So the Battle of Solferino was a battle during the Italian War of Independence. It lasted 14 hours with more than 300,000 troops and as many 30,000 killed and many more thousands wounded. Henri Dunant, a Swiss businessman, was visiting the region and volunteered to care for the wounded following the battle. In the 3 years following, Dunant wrote of the horrors of war and the struggles to provide care in his book, A Memory of Solferino. And in that book, he called for 3 changes: for the establishment of national relief societies to care for the wounded, for an international relief society to support their efforts, and for an international convention to protect the wounded. So Dunant and his colleagues founded the International Committee of the Red Cross and the wider Red Cross Red Crescent movement, and also contributed to the agreement of the First Geneva Convention. The current president of the ICRC has accurately described the situation we're faced with today when she says, "When conflicts are characterized by widespread destruction and violation of international humanitarian law, the pursuit of development and peace becomes an unattainable ambition." She goes on to say that compliance with international humanitarian law prevents violations and abuses, it reduces the cost of war while maintaining a pathway to ceasefire agreements, and eventually to lasting peace, functioning economies, and a healthy natural environment. Frontline humanitarian action can stabilize tensions in communities. When IHL is respected, lives are saved, hospitals and schools remain open, markets can function, and reconciliation after the conflict becomes easier. And I'll note I'm using the language of conflict, and sometimes that language is questioned, but I use it interchangeably with war simply because it's the legal language of the treaty. So I want to come back to what I mean when I talk about IHL, or International Humanitarian Law. This is the law of armed conflict, or the rules of war. It's the law that applies during wartime to protect civilians and those no longer participating in hostilities. It also restricts the means and methods of warfare, that is, what weapons can be used and how one can use them, and with the aim to limit and prevent suffering. So all of us today are sitting in this central column under peacetime, and the law that applies are our international human rights law and our domestic law. These are legal principles that also apply when there are internal disturbances or riots. But what we're talking today is war, and so we're looking at what happens when there is a declaration of war or any other armed conflict between two states. So it doesn't need a requirement or knowledge of war. If you'll remember, in the early days of the full-scale invasion of Ukraine, President Putin said that it was a special military operation. That characterization didn't negate the fact that we've moved into the international law relating to an international armed conflict. And so here, the Geneva Conventions apply. And so it sets out the rules for wearing parties and the protection of civilian objects. So for example, simply put, it distinguishes between civilians and civilian objects, military and military objects, sets out the protections of prisoners of war, and also the rules of occupation. Other laws also do apply, including, for example, regarding the regulation of weapons, like the Ottawa Treaty or the Anti-Personnel Landmine Treaty. On the other hand, we have circumstances where it's not an international armed conflict between states, but that there is a sufficient protracted armed violence between government authorities and an organized armed group, or between two organized armed groups with sufficient intensity and organization that brings us into the realm of a non-international armed conflict. Here, the law articulated in the treaties is a little more narrow, but the fundamental principles are still there. And then, in all circumstances, whether we're talking about an international armed conflict or a non-international armed conflict, we always have the application of jus cogens and customary international law. So customary international law are the rules that come from a general practice accepted as law by states and that exist independent of treaty law, so independent of the Geneva Conventions, for example. And jus cogens are the norms of international law that cannot be set aside. So this includes things like the prohibition against torture or genocide. The Geneva Conventions, the four that apply in an international armed conflict, have been ratified by all states globally and ultimately seek a balance between military necessity and humanitarian protection. It includes the principles of distinction, of proportionality, the notion of necessity, the principle of humanity, among other things. In the context of international armed conflicts, and that's what I'll talk about today for simplicity, these are laws and principles that apply to states, which are required to uphold them. And we should not be under any impression that these rules solve the suffering in war, but simply that this framework helps facilitate and facilitate the minimization of the human cost. And so in this sense, I talk about IHL as a humanitarian imperative. And there's so many things we could talk about in the context of IHL. Indeed, it recognizes that civilian populations of a state is entitled to receive humanitarian assistance and specifically covers the activities of impartial humanitarian organizations. And that's what I want to focus on with you today. And there are two key parts to highlight in this regard. First, in regard to the activities of impartial humanitarian organizations. And second, the access that relief and protection of those organizations is facilitated. Article 9 of the First Geneva Convention sets out the protection of humanitarian activities. It's not just a recommendation, it's a legal obligation of states. And Article 9 states, the provisions of the present convention constitute no obstacle to the humanitarian activities which the ICRC or any other impartial organization may, subject to the consent of parties to the conflict, undertake for the protection of wounded and sick, medical personnel, chaplains, and for their relief. In respect of international armed conflict, this has been enshrined in all 4 Geneva Conventions and sets out those protections for different categories of persons. So this includes the wounded and sick. It includes the shipwrecked, medical personnel, chaplains, prisoners of war, and of course, civilian persons. And the article specifically confers the right to the ICRC and humanitarian organizations that are impartial. So in order to qualify as a humanitarian organization, there's no requirement to the scope of the activities per se. So for example, an organization that's focused solely on development activities prior to the outbreak of a conflict, maybe perhaps like a Rotary Club, for the purposes of Article 9, is a humanitarian organization, so long as they act impartially, during an armed conflict, even if they're carrying out those other activities. So this includes the Rotary Club in Ukraine. And I know many of you have networks and building with the Rotary Clubs there and providing humanitarian assistance. And so while they're development organizations, they're also humanitarian organizations for the purpose of international law. So as mentioned, the Geneva Conventions requires that humanitarian organizations wishing to offer their services and to have that right of protection are impartial. So impartiality refers to the attitude to be adopted in relation to persons affected by the armed conflict when planning and implementing the activities. So for example, any activities undertaken would not make any discrimination based on nationality, race, religious beliefs, language spoken, or political opinions. The second key obligation in IHL, as it relates to humanitarian actors, is about humanitarian access. The 4th Geneva Convention, regarding the protection of civilians and the obligations of occupation, requires states to allow, quote, the free passage of all consignments of medical and hospital stores, intended only for civilians, and the free passage of all consignments of essential foodstuffs, clothing, and tonics, intended for children under 15, expectant mothers, and maternity cases. Article 70 of Additional Protocol 1 to the Geneva Conventions, which I have on the slide, broadens this obligation, and is to cover, quote, rapid and unimpeded passage of all relief consignments, equipment, and personnel. And this broadening is accepted by, of course, the states that have ratified this additional protocol, but also far more broadly by those who have not, and so it's viewed as an obligation under customary international law. So I recognize that these are heavy texts and may seem confusing, but we also have courts that interpret these articles and principles to help us understand what the provisions mean. So for example, in the case of military and paramilitary activities in and against Nicaragua, this was a case between Nicaragua and the U.S. regarding accusations that the U.S. was creating, training, financing, and directing the Contras in the 1980s. The International Court of Justice looked at, among other things, including what constitutes the lawful use of force, what the provision of humanitarian aid meant. And it's useful because it gives us guidance about the scope of protection, what activities can we do as humanitarian organizations. And the court said, there can be no doubt that the provision of strictly humanitarian aid to persons or forces in another country, whatever their political affiliations or objectives, cannot be regarded as unlawful intervention, or in any other way contrary to international law. And specifically, the court cited the fundamental principles of the Red Cross and Red Crescent movement, which sets out the characteristics of that aid. And that's, I quote, no discrimination as to nationality, race, religious beliefs, class, or political opinions. It endeavors only to relieve suffering, giving priority to the most urgent cases of distress. And the court goes on to say that an essential feature of truly humanitarian aid is that it is given without discrimination of any kind. So part of my job when I was in Ukraine was to support the NGO and the humanitarian community with advice on operational ethics and international humanitarian law. So for example, in the context of the organization's humanitarian logistics platform, which facilitates transportation and storage of goods for local and international organizations, would be to do due diligence processes and confirm whether the delivery of certain types of goods could be delivered to certain types of delivery points to be consistent with the protections under international law, and then similarly, whether those provisions were sufficient to ensure the safety of our staff when they made those deliveries. So, for example, to military hospitals. I also undertook and supported dialogue with other humanitarian actors on the importance of ensuring distinction between civilian and military objects. So it was very common to see, especially at the beginning of the full-scale invasion, the use of khaki colors or military-adjacent clothing or vehicles in Zelensky style, and or the misuse of the Red Cross emblem. And this was problematic because it may result in the targeting of persons or objects in good faith. And so while the obligation to ensure distinction and to ensure that targeting is legal is on the states party to the conflict, so in the case of Ukraine, Russia and Ukraine, there remain risks for organizations and their personnel. So ensuring that humanitarian actors are clearly identified and that aid is truly solely humanitarian in nature protects that aid and protects the civilians whom it is being delivered. I also developed and led trainings on international humanitarian law and the humanitarian principles, similar to this discussion today, and to look at the frameworks that applied to work through some of the ethical dilemmas that arose for the organization and for its staff. So now that I've covered the legal frameworks, in short, some of the rules, I want to focus on some of the rules specific to humanitarian organizations and the principles that drive that work specifically. So the fundamental humanitarian principles of humanity, impartiality, neutrality, and independence constitute the four common principles to international humanitarian law and to the Red Cross and Red Crescent movement, as well as to the United Nations and characterized in its resolutions, and other regional organizations such as the European Union and the African Union. These principles are also articulated in the Code of Conduct for the International Red Cross Red Crescent movement and non-governmental organizations in disaster relief. Shelter Box, which some of you know, is one of these organizations that has signed on to the Code of Conduct. I'm not aware that Rotary International has signed the code, but I encourage you to think about it as returnees are the humanitarian actors in their own community when war occurs. You're the local actors now, and you're the local actors in disasters and emergencies and conflicts. And so these principles equally apply and are so important. Now I want to look at the definition of these principles. And as we go through them, I'm not going to test you, I promise, Brian. As we go through them, I'd like you to think about each of these principles and how it has applied or might apply to the Rotary projects you do either in Canada or the international projects you've engaged in. So first, we have humanitarian aid is provided on the basis of need alone, giving priority to the most urgent cases of distress. So this is referring to impartiality. This is a principle that's explicitly referenced in the characteristics of relief organizations in the Geneva Conventions. Second, it says humanitarian actors formulate their actions autonomously, uninfluenced by economic, political, or religious powers. So here we're talking about independence. Third, human suffering must be addressed wherever it is found. The purpose of humanitarian action is to save lives and relieve suffering. And this, of course, speaks to the humanitarian imperative. And so I just want to look at a situation where these principles are engaged in practice. So, and where these principles may be at odds or perceived to be at odds. So, for example, imagine you're an organization that needs access to be granted to by a local authority in order to provide humanitarian assistance. In that request to the local authority, they tell you that the only way you'll be allowed to undertake intervention is if the activities are directed solely to women and girls. How should the organization respond? So first, we can start by, let's look at impartiality. These obligations require us to intervene based on need. Therefore, if there are populations that have a need or a greater need than women and girls in the community that we're looking at, the demands by the public authorities would be contrary to that principle. Second, let's look at independence. So the condition placed by the authority is contrary to this principle because the humanitarian action would be at the direction of political power. Third, though, humanity, which many argue and I support, is that our overarching principle, humanity, that we must address human suffering wherever it is found. And we also have to recognize that in war and in situations of emergencies, women and girls often face disproportionate impacts. And so addressing their needs clearly falls into the framework of humanitarian assistance. So how do we respond? Our principles are in tension. Ultimately, the answer I think and believe is dialogue and negotiation. It's setting out the obligations legally and principally to the partners we work with, other organizations, local authorities, national governments, international organizations, about what these obligations are and the rationale for them, why we are prioritizing those most in need, why we remain independent, what is the importance of that distinction, and also that the ultimate driver is humanity. And it's successful. The conversations are ongoing in peacetime as much as they are important in wartime. Finally, I want to talk about the fourth principle about neutrality. So humanitarian actors must not take sides in hostilities or engage in controversies of a political, racial, religious, or ideological nature. And I want to speak to this specifically because I think it is the most difficult, or it is often the most difficult today, and one that raises the most challenges for people individually and organizationally in terms of ethical dilemmas. And so where you have more than these two principles that arise, that you have humanitarian needs, but the principle of neutrality might suggest that you can't speak out. And when I talk to people working in humanitarian organizations, and we talk about these ethical dilemmas, we look at it from a personal perspective, what your personal values and ethics say, and how that relates to the ethics and values of the organization you're working for. And obviously, you want to have that alignment. And I think with so many Rotarians, we do have that alignment with the principles and values of the organization. But there are also circumstances where sometimes that's challenged. So, for example, in Ukraine, the organization I worked for undertook explosive ordnance risk education. So we went out into communities and informed people about the risks of unexploded ordnance, about landmines, about cluster munitions, and matters to undertake safe behavior when you had risks like missile and drone attacks. And in that, they're required to speak about cluster munitions. And you may remember or are aware of conversations around the U.S. transfer of cluster munitions to Ukraine over the last 2 years. And it was a hotly contested subject among humanitarians in the disarmament community, because there is a treaty that sets out to prevent the transfer and use of cluster munitions, as well as what many in Ukraine argued as the military necessity. And there were the feelings that many people felt in supporting that transfer of weapons. And so what was required with our staff in conversation was to identify what that personal need is, and the rationale behind the organization's position of not to support those weapons, because we know they disproportionately impact civilians, they are indiscriminate, and simply that it's against the principles of humanitarian law. And so in addressing these kinds of ethical dilemmas, we really focus on humanity. So what are the humanitarian needs that the organization is meeting, and why is that neutrality important? So here it was about speaking about the risks of cluster munitions. But the other important part in these conversations is that neutrality does not mean silence. And that especially for humanitarian organizations who are operating under these frameworks, under humanitarian law, and under the principle of neutrality, it's that advocacy relating to issues that are impacting populations is principled, so that we speak out, but we speak out in a principled way about violations of humanitarian law, about international criminal law, about human rights, and about those humanitarian principles that guide our work. And really, at the same time, we have the ethical dilemmas, and I think, well, what's the point? Why are we why have this? Why not just do the work and address the needs so urgently? And there's a couple of reasons why organizations have these rules, and there's two, I think, that are most important. First, the principles allow humanitarian action to be distinguished from the activities and objectives of other actors. So distinguished from the military, distinguished from local government, and organizations that may have a mandate that is not neutral, which are also important in any response. The second thing is that principles help to ensure access to affected populations and the safety of humanitarian personnel and beneficiaries. So where there is a perception of compliance with the humanitarian principles, whether that's, and I focus on perception because it might be real, that if there's misinformation and disinformation, the fact that in reality word compliance doesn't actually matter, but it allows for us to advocate for humanitarian access to communities, that our staff are not targeted, that we can go to areas that are near the front line and provide that assistance. So humanitarian principles and international law provide a framework to guide humanitarian work, facilitate that work, and to ensure civilians and relief organizations are protected. My hope in sharing with you this framework and the rules and principles will help you reflect on your work in Rotarians and what that intervention looks like in your communities and internationally. And I know today we're a bit tight on time, but I'm really happy. I think we have about 7 minutes and 50 seconds to take some questions now. But I'm also here throughout the evening and tomorrow and happy to talk with you all. Finally, I just want to say thank you again for all your support and belief in me. My experience in Rotary has been life-changing. I'm constantly inspired by this community, how you support local communities, how you build bridges internationally, and it's changed my life. And I can't thank you enough for that, all of you. And it might be cliche, but I do think that if every 15 or 16-year-old had the opportunity to be a youth